Today we'll talk about every parent's worst nightmare, and that is injuries to an unborn child. We'll talk about how Georgia law views injuries like that and whether compensation is available for them. This topic under Georgia law breaks down into two categories. One is injuries that cause the loss of life, like a miscarriage or stillbirth or other loss of the baby's life. And then the second category, which we'll talk about second, is prenatal injuries that don't result in the death of the unborn baby. Now, if you or a loved one who was involved in a car accident or something like that, where the unborn baby lost his life, whether a claim exists under Georgia law depends on when it happened. So if the car accident happened after what Georgia law calls the quickening, then there is a claim. If it happened before the quickening, there is not. Now, if you've never heard the term quickening before, you're not alone. I don't think anyone other than lawyers probably have, because it's an old school term that comes from Old English law, specifically, if I remember right, from 1803 in a fellow named Blackstone. So it isn't used by modern people, it isn't used in modern medicine, but courts have actually been pretty clear about what quickening means. A baby is, quote, quick, close quote, when the baby is able to move inside the mother's womb. Now, what kind of movement are we talking about? With the sonogram or other modern medicine, you can see some kind of movement basically at any point after conception. So what does quickening mean? Well, quickening refers to movement, the baby being able to move in such a way that the mother can feel it. Like feel the baby kicking. Or if the dad puts his hand on his wife's belly and feels the kick, then the baby is said to be quick. The quickening has occurred. To bring a claim for the loss of life of a baby before birth, you have to have some evidence that the quickening had occurred. That can be the mom testifying that yes, I felt the baby kicking. The father or someone else saying I could feel it when I put my hand on her belly. Testimony from a doctor. Something like that. Courts have said that the quickening normally occurs sometime between 10 and 16 weeks into the pregnancy. So the next question becomes, what kind of compensation are we talking about? If you or someone you love has lost a baby and it was after the quickening, it was through the fault of someone else, then what sort of compensation are we talking about? And the answer is that it is like any other wrongful death case in Georgia. The measure of damages is the, quote, full value. This comes from a statute or law enacted by the legislature. The full value of the life that was lost from the point of view of the person who lost it. Now that's hard to figure, but the answer, to the extent this helps, is that the value of the claim is the value that the infant would have put on his or her life had he or she lived. So, Georgia's very serious about the value of life, and that applies here too. So what about prenatal injuries that don't result in death? Well, that's a different sort of kettle of fish. This can happen. You can imagine a prenatal injury, whether it's a car accident or something that a medical treatment person did wrong, or a fall or anything like that. What about injuries that don't cause death but do hurt? Like if the baby suffers, a broken bone in the womb, and for that reason is born with an arm that isn't like it's supposed to be. Or the baby suffers a loss of oxygen to the brain for some period and has mental challenges after it's born. Are those compensable? The answer is yes, but as to when, that is after birth. So compensation for injuries that don't result in death are only available if the baby is born alive, and of course after the baby has been born alive, so you can see what those damages are. And what kind of compensation is available? Well, it's like any personal injury case. The compensation is for the loss. So if we're dealing with, I'll use an easier example, like a broken arm, well, then the damages would be for that loss, for whatever medical bills it took to get it right, whatever permanent injuries are going to be suffered, and those kinds of things, and also pain and suffering. Note that pain and suffering is not available over here on the loss of life side, but for prenatal injuries that don't result in loss of life, then pain and suffering can be available if proven. Like anything else in a court, you got to prove that it happened, and here that may require the testimony of a doctor or another expert.